Hello everyone, welcome back to Legum Prudentia. Today we will talk about security agreements and why it is very important, and the most important thing is how to draft a legally sound security agreement. So what is a security agreement? A security agreement is a contract that gives a creditor rights over an asset if the debt isn't repaid. At its core, it's a contract where a debtor gives a creditor rights over a specific asset, the collateral, to secure a debt. If the debtor fails to pay, the creditor can enforce their rights against that asset before unsecured creditors even get a look in. In India, you will usually see this take the form of a hypothecation agreement for a movable asset, a pledge, a mortgage for immovable property, or a charge document, depending on what's being secured. In the US, under UCC Article 9, it's simply called a security agreement, and it's perfected by filling what's called a financing statement. The terminology changed, but the core idea, collateral backing, a promise to pay, is universal. Why security agreement matters? The first thing is it protects the creditor, gives a real enforceable claim over an asset, not just a promise on paper. Makes credit more affordable. Secured lending carries lower risk, so it usually comes with a lower interest rate. Determines priority in insolvency. Under India's IBC waterfall, secured creditors are paid ahead of unsecured ones. Key parties to the agreement. Every security agreement has at minimum two parties. The debtor is who owes the underlying obligation and who grants the security interest in their asset. The secured creditor, usually a bank, NBFC, or lender, is the one who receives that interest and can enforce it on default. Sometimes you will also see a grantor, a third party who isn't the primary borrower but who steps in to place their own asset or personally guarantee repayment. Getting the parties correctly and precisely identified, full legal names, registered address, CIN or PIN details for companies sounds basics, but it's one of the most common sources of enforcement problem later. So in our security agreement, we have mainly two parties, the debtor and the secured creditor. In security agreement, we also have guarantor, which is optional. Types of security interest in India. In Indian law, the right security structure depends heavily on the asset. A pledge involves transferring possession of movable goods, things, shares, gold, or warehouse receipts to the creditor. Hypothecation, hypothecation is used when the debtor needs to keep using the asset like inventory, vehicles, or receivables. The creditor holds a charge without taking possession of property, land, and buildings. A mortgage applies to immovable property, land and buildings and is governed by the Transfer of Property Act 1882, and a charge is broader concept especially relevant for companies under the Companies Act created without any transfer of possession at all. Getting this classification right at the drafting stage matters. It determines which statute governs your agreement and which registration regime applies. So, for types of security interest in India, we have pledge, mortgage, hypothecation, and charge. Now, we will talk about what is the scenario of the security agreement in Indian perspective and global perspective. It's worth a quick global comparison before we go further because In India, security agreements sit under a patchwork of laws: the Indian Contract Act, the Companies Act for charge registration, SARFAESI for bank enforcement, and IBC for insolvency priority. Charges get registered with the Registrar of Companies using from CHG1 and separately on the SARSAI portal, which was built to stop fraudulent multiple lending against the same asset in the US. By contrast, it's all consolidated under Article 9 of the Uniform Commercial Code, one security agreement perfected by filing a single UCC1 financing statement with the different mechanics but the same underlying goal: give the world notice of who has first claim on an asset. What is the legal framework in India? So here we have Indian Contract Act 1872. Before we walk through the drafting process, let's map out the laws that actually govern this in India. The Indian Contract Act 1872 gives you the basic rules of a valid contract: offer, acceptance and consideration. The Transfer of Property Act 1882 governs mortgages over immovable property. The Companies Act 2013, specifically Section 77, requires companies to register any charge they create. Miss that filling window and the charge can become void against the liquidator and other creditors. SARFAESI 2002 is what lets bank and NBFCs enforce security interest directly deposing and selling secured assets without first going through a lengthy civil suit. The IBC 2016 sets out exactly where secured creditors sit in the payment priority when a company goes into liquidation, and SARFAESI is the central registry that records security interest across lenders, specifically to stop the same asset being placed twice. So, in legal framework in India, we have Indian Contract Act 1872, Transfer of Property Act 1882, Companies Act 2013, SARFAESI Act 2002, Insolvency and Bankruptcy Code 2016, and then SSI registration. Now we will talk about essential element for a valid agreement. Miss any of these and the agreement is vulnerable to challenge. Before we walk through the drafting process, let's lock down the four things every valid security agreement needs. 1. The parties must be clearly identified with full legal names and confirmation that whoever signs actually has the authority to bind the party. 2. The collateral must be described specifically enough that a third party could identify and locate it. Vague descriptions are one of the top reasons courts strike down security claims. 3. The underlying obligation, the actual debt being secured and its amount need to be stated clearly. And 4. The document must be properly signed, witnessed if your state stamp law requires it, and stamped correctly, because an unstamped or understamped document can be inadmissible as evidence in Indian courts. Attachment versus perfection. Understanding the difference is the key to real enforceability. The security interest becomes enforceable between the debtor and creditor once value has been given. The debtor has rights in the collateral and the agreement is signed. Perfection. The security interest becomes enforceable against third parties, other creditors, or liquidators, typically through registration, ROC filing, SARSAI, or UCC1 filing. Here is the whole drafting process, start to finish, in 6 steps. Step 1. Identify the parties and the exact debt or obligation you are securing. Step 2 is describe the collateral precisely enough to be legally sufficient. Step 3. Draft the granting or hypothecation clause, the operative language that actually creates the security interest. Step 4 is add representations, warranties, and covenants that protect the creditor over the life of the loan. Step 5. Set out what counts as default and exactly what remedies the creditor can pursue. And step 6. Execute the document properly. Pay the correct stamp duty. Register it wherever the law requires. We are going to spend the next several minutes going clause by clause through step 3, 4, 5 and 6 because that's where most drafting mistakes actually happen. Now, what we will talk about the guaranteeing and hypothecation clause. Let's zoom into the granting clause, sometimes called the hypothecation clause, depending on the asset type. This is the single most important sentence in the entire agreement because it's the operative language that actually creates the security interest you want clear. Present tense verbs, words like hypothecates, grants or charges, not vague future promises like shall grant. It should tie directly to a defined term for the secured obligation, so there is no ambiguity about what that this security actually covers, and it should cross-reference the schedule where you describe the collateral in full detail rather than trying to cram every asset description into this one sentence. Describing the collateral. Vague description are the hashtag one reason security claims get challenged. What you need to do, use a specific description, serial numbers, survey numbers, account numbers, or a defined schedule of assets. What you need to avoid is broad, vague terms like all assets without a schedule. Courts may read this narrowly or strike it as uncertain. For changing asset, use a description by type, all present and future inventory for revolving collateral like stock. Representation and warranties. Statement of fact, the debtor confirms as true and signing. The debtor owns the collateral free of any other charges or encumbrance. The debtor has full authority and power to grant the security interest. The collateral is accurately described and where relevant properly insured. No litigation or claim is pending that would affect the collateral's value. Covenants of the debtor. While representation are promises about the past and present, covenants are ongoing promise the debtor makes for the life of the agreement. Common ones: maintain and insure the collateral properly throughout the loan term. Don't create any further charge or encumbrance over the same asset without the creditor's consent. This protects the creditor's priority position, allow the creditor reasonable inspection rights over the collateral or related records, and promptly notify the creditor of anything that affects the asset, damage, loss, or if it's moved to a new location. These covenants are what keep the collateral's value protected between signing and repayment, and a breach of covenant is usually itself drafted as a default trigger. Events of default. Events of default are the specific defined triggers that give the creditor the right to act. The most obvious is non-payment, missing principal, interest, or any other amount due. Next is breach of any representation, warranty, or covenant we just discussed. It is insolvency related. The debtor going into winding up or a corporate insolvency solution process being initiated against them under the IBC. And fourth is any unauthorized dealing with the collateral itself, selling it, transferring it, or creating another charge over it without consent. The key drafting tip here: be exhaustive and specific. A vague default clause like or any other material breach without more detail invites disputes about whether default actually happened. Once default is triggered, what can the creditor actually do? On the contractual side, the agreement itself should spell out the right to take possession of the collateral, sell it, apply the proceeds to outstanding debt, and importantly, claim any shortfall from the debtor as an ordinary unsecured debt. If the sale doesn't cover the full amount, on the statutory side in India, banks and NBFCs get a powerful shortcut. SARFAESI lets them enforce security directly, take possession and sell the asset without first going to court, subject to the notice periods the Act requires. Where SARFAESI doesn't apply, you are generally looking at a civil suit for recovery, which is slower, and if the debtor is already insolvent, the creditor's claim gets routed through the IBC process instead, resolved according to that priority wall we mentioned earlier. It's tempting to treat boilerplate as filler, but skipping or copy pasting it carelessly causes real problems. Governing law and jurisdiction tells everyone which law applies and which courts will hear a dispute. Critical in cross-border lending, notices sets out exactly how and where formal communications like a default notice must be delivered. Get this wrong and a court may find your notice was never validly given. Amendment requires that changes to the agreement be in writing and signed by both parties, protecting against informal side agreements. Severability keeps the rest of the document alive. If one clause is later struck down, assignment addresses whether either party can transfer their right. Important if the lender later wants to sell the loan, an entire agreement confirms this document replaces all earlier drafts and discussions, so nobody can point to an email as a side deal. Registering and perfecting your security interest. In India, this is what turns a signed agreement into a protected one. Registrar of companies. From CSG 1, companies must register a charge without 30 days of creation. Miss it and the charge can be void against a liquidator. Survey registration. Bank and financial institution record the security interest centrally to prevent duplicate financing on the same asset. Stamp duty. The agreement must be stamped correctly under the applicable state stamp law, or it may be inadmissible as evidence. Priority among competing creditors. So when two creditors both claim security over the same asset, who wins? The general rule is that the creditor who registers or perfects the first generally has first claim, not necessarily whoever lent the money first. Between two registered charges over the same collateral, the timing of registration is usually what decides priority. In a liquidation under the IBC, secured creditors who have properly enforced their interest rank ahead of unsecured creditors and in most cases ahead of operational creditors too. And here is the sobering part, an unregistered charge, even if it was perfectly valid as between the original debtor and creditor, can be treated as unsecured, worthless in priority terms against a liquidator or other creditors who did register. This is exactly why perfection isn't optional paperwork. It's the difference between getting paid and getting nothing. Common drafting mistakes to avoid. Let's bring it together with the 5 mistakes I see most often. 1. Vague collateral description. All asset with no schedule is an invitation for a court to read your security narrowly or reject it outright. 2. Missing the registration deadline. Filling Form CSG1 even a day late without seeking condonation can leave your charge void against a liquidator. 3. Under-stamping the document. This can make it inadmissible as evidence until you pay the deficient duty penalty, which can take months in a dispute. 4. Undefined default triggers. Relying on vague language like material breach without specifics just invites litigation over whether default actually happened. And 5. Ignoring suicide feeling, skip it, and you have no real protection against the same borrower. Final drafting checklist. Before you finalize any security agreement, run through this checklist. Are the parties fully and correctly identified with confirmed signing authority? Is the collateral described specifically with a schedule attached? If it's a list of assets, does the guaranteeing clause use clear present tense operative language tied to a defined secured obligation? Are your warranties, covenants, and default triggers all clearly spelled out, not left vague? Is the document properly signed, witnessed where required, and correctly stamped? And finally, is the charge registered with the registrar of companies and, where applicable, on SERSI within the required deadline? If you can tick every one of these, you have got an agreement that's not just signed, it's actually enforceable. Let's wrap up. A security agreement is only as strong as its weakest clause. A vague collateral description, a missed registration deadline, or an understamped page can undo months of otherwise careful drafting. Remember the core sequence: identify your parties and the debt, describe the collateral precisely, draft a clean granting clause, back it with real warranties and covenants, define your defaults and remedies clearly, and then critically execute, stamp, and register it correctly. Get all of that right, and you have turned a simple promise to repay into a genuinely enforceable right over real property. Thanks for watching. If you found this useful, share it with someone drafting their next financing document, and I'll see you in the next one.